Great. Welcome back to Senate Education. Laura Yang is with us. Thanks so much for joining us, Ms. Yang, from the Human Rights Commission. You were with us early on to talk about an act relating to miscellaneous ed, but specifically a draft amendment that we have on bullying, harassment. We've continued to take testimony. We spent quite a bit of time yesterday hearing from Ms. Heather Lynn, who's an attorney, I believe in Burlington, who provide us with a lot of good background information as well. And so we thought we'd have you in. And one of the things that's helpful in this committee process, honestly, is a little the back and forth.
Yeah.
You know? So if you wouldn't mind telling us your thoughts on perhaps, we'll leave it there. Whatever you would like. You asked to come in, whatever you would like to say.
Yes, so thank you so much for having me back in. And I know you've heard a lot of testimony on this, and I really appreciate that. And so I'm going to keep my testimony brief today and then answer your questions if you have any. And I mostly want to spend my time responding to the concerns that you all have brought up.
Okay.
Because to me, that's the most important. So the first concern is one that I've heard from Senator Gulick and maybe you too, Senator Campion, which is that maybe this bill might have unintended consequences, resulting in more suspensions and expulsions of kids, which might further exacerbate the school to prison pipeline. And I want to share that, you know, students who are Black, students with disabilities, LGBTQ youth are the primary victims of peer-to-peer harassment. They are not the perpetrators. And they also happen to be disproportionately disciplined, suspended, expelled, and represented in the juvenile justice system. So they are also the primary victims of the school to prison pipeline. And I mean, why is that? Because one of the things that I have learned as the executive director of the Vermont Human Rights Commission, and having spoken to a lot of people who haven't read a lot of studies, is that when marginalized community members are the victims, we tend to ignore it more, and we tend to be more hyper-focused when they engage in bad behavior. It is a phenomenon that not only shows up in schools, but in workplaces and in policing as well. I would say that if you want to address the school to prison pipeline, you should introduce a bill that limits or eliminates suspensions and expulsions in schools, that limits referrals to the police for behavioral issues, that limits police presence in schools. But you don't address the school to prison pipeline by keeping the harassment standard unreasonably high. The other concern that I did hear come out of this committee is the concern that we're holding schools accountable for behavior that has been learned by their parents or the community. And that is already the law. And it is good law because we should be held responsible for the environment over which we have control. Schools don't have control over the beliefs of parents and students, but they can control the school environment and reduce racist or sexist behavior within the school. That's what we ask of employers and businesses. So a supervisor cannot stop a man from being sexist or having sexist beliefs, but a supervisor can stop that employee from treating women differently in the workplace. The behavior is what we can curb and what we can limit and reduce. Remember that this is not a strict liability standard, despite some of the testimony that has suggested otherwise. Schools cannot be sued unless students can prove that the harassment occurred because of their membership in a protected class. Hard to do. And schools cannot be sued unless the student can show that they put their school on notice and their school failed to do anything. That's notice plus failure to act. Not just notice, but notice plus failure to act. And then the third issue that was raised by the witnesses that opposed this amendment is that these Title IX regulations that govern sex harassment are coming out in May, and we gotta wait for them before we move forward. And the only reason you would wait for the Title IX regulations to come out is if there's the possibility that the regulations will conflict with the changes here. And here's why it will not. We already know what those regulations will be. They've already proposed what those will be. And most of the time, almost like 90% of the time, the ones that are proposed are the ones that are adopted. Many of the regulations are complementary, not contrary or contradictory to this bill. And the regulations address timeframes and notice requirements, and they expand the definition of what sex-based harassment is to include other forms of like gender identity, sexual orientation, and so forth. The proposed amendment that is before you broadens the definition of harassment, gets rid of a insurmountable legal standard. And it can do that without any conflict with the regulations, because state law can be more protective. It can always be more protective. In fact, Vermont has been more protective for years.
So much.
Yeah, of course.
Can you explain what you mean by instrumental legal standard?
The severe or pervasive standard, yes, has become such that it is very difficult, even in a case where most of us would consider to be harassment, could not get in the door. And what I mean by could not get in the door is they don't get to the jury even. They lose before the jury even gets to hear, before there's even a trial. So Vermont has been at the forefront, has been the leader on civil rights and human rights issues. The Department of Education in 2023 is now only considering regulations that will consider gender identity and sexual orientation as an expanded definition of sex-based discrimination. Vermont did that years ago. Despite the fact that the federal government issues all of these public assistance programs, the federal fair housing laws do not cover discrimination on the basis of public assistance. Vermont did that years ago. Vermont has been the first and on many civil rights and human rights issues, and it should not back down now. In fact, now is the time to do it. When the Department of Education issues those Title IX regulations next month, the Agency of Education in Vermont will be rewriting its model policies this summer. This is the time that it should also be reviewing the definition of harassment for students in Vermont. Waiting requires them to review those policies again next year, which really isn't a good use of resources or time. The one consistent theme and message that we've heard across the board, no matter who has testified, and that we all agree on, is that harassment is occurring in our schools more than ever. Everybody is in agreement on that. The question then is, what is our role in addressing that? And there's one thing I've learned is that there is no singular answer. There's no one source of discrimination, like there is no one response to discrimination, and there is no easy path. It requires all of us to address what is within our purview. Everyone has to do their part. Parents have to do their part, no doubt. Schools have to do their part, employers have to do their part, police have to do their part, advocates have to do their part, and as legislators, you have to do your part. Your part is to address the laws. That is what is before you. The institutions have said that these current laws and policies are robust and no changes necessary. And a lot of witnesses have testified before you that those laws are not, and that BIPOC, LGBTQ kids and kids with disabilities are left out cold. The choice is yours, undoubtedly, but choosing not to move forward, choosing to wait is still making a choice. I propose to you that this may be one of the most, if not the most important civil rights bills that you will advance as legislators on behalf of kids in Vermont. And to me, there's only one right choice, and we have to choose kids every single time. So thank you for allowing me this last response to this.
Oh, absolutely. Yeah. It doesn't have to be your laughing.
Oh,
You can come whenever you want.
No.
Thank you so much, both of you, for advocating for kids. So incredibly important. I spent my whole life advocating for kids
Yeah.
as well. And even today, I'm still getting emails and texts from students who are still relying on me as their trusted adult. I just got a text yesterday from a kid. She hasn't been my student in like 6 or 7 years, and she wants me to be a reference for her for a job.
Yeah.
I'm happy to do it, but it also makes me sad that 7 years later, I'm still her trusted adult. So I've already, you know how I feel about unintended consequences in my particular district, which I'm hoping Sparks can come in and speak to that in our Office of Equity, because I want to hear from them.
Yeah.
But yesterday I got a whole new sort of like existential angst having listened to testimony, which is that for me, education, and specifically public education, has always been and is potentially the great equalizer, right, of our democracy. It is, as far as I know, the one institution that can potentially lift kids out of poverty.
Mhm.
I'm really worried about that institution right now. It is, and I'm asking you the same question I've asked multiple people. We are on the verge of crisis. We're struggling now, I would say, public education as a whole. I guess I don't agree that this is an insurmountable legal standard, having talked to folks who are working in schools and who are, you're right, dealing with a lot of bullying. And they are maxed out in many, many ways. I've mentioned this before. There isn't enough staff. There isn't enough, folks are retiring and quitting. I know an administrator who quit because she couldn't keep up with the Title IX issues. True story. Behavior issues off the charts due to the pandemic and other issues. I mean, there were yesterday on NPR, I recommend you all listen to the data that's starting to come out around social media and screen time and depression and anxiety, which is, we're finally getting that data. So again, my thoughts yesterday were, here we are putting yet another I don't know, workload, another issue, another burden on our schools that are already stressed out to the max to help kids. But are we not undermining the very institution that is there to lift them up by putting this one more layer on top of everything else right now? That's where I'm conflicted right now, because we don't want to tear down the institution and degrade it to the point where it can no longer function as a way to serve our kids. And maybe this is hyperbolic, maybe I'm over exaggerating. I wish someone could tell me that I am, but no one's been able to tell me that yet in the last 24 hours. So again, I'm waiting to hear from our Office of Equity in Burlington. I'd love to hear from Lucy and Essex as well. But that's from where I'm sitting, that's how I see things right now. But again, I really appreciate your advocacy. It's very important.
I really appreciate that. And my response to that is two things, which is the burden that is already placed on our schools is already there. And we're talking about changing the standard for how they look at that, and not creating more trainings, but changing the way those trainings are done to encompass a new way to look at harassment. So it's not more, it's different. And the other thing I want to say, just completely out of respect for that position, is that the same conversation is also happening in Senate and House Judiciary Committees whenever there's a bill that proposes to relook at civil rights and the rights of people of color and LGBTQ and people with disabilities, particularly people with psychiatric disabilities. And the same argument is made that the police are quitting, that there is not enough police people who are, or enough people who are interested in becoming police officers. That is also the argument that is made, is that they are also bombarded what they are being tasked to do. And I don't even disagree.
I don't think we should compare police to educators. I just don't.
I'm comparing the similarity in the conversation about when we advance civil rights stuff, that the argument is also made that we are short-staffed, that there is not enough people that are interested in doing this work, and that people are quitting. And my thought is that there are different responses to both of those things. You can advance civil rights of the people who are most marginalized in your community by changing the harassment standard, and also support schools and teachers in a different way. But that bill to support teachers and schools is not before you. The bill that is before you is to change the legal standard. Now, if we want to have a companion bill to this that says we need to provide pay more so that we can attract people, so that people don't quit. We need to create a bill that says we don't suspend or expel people for being perpetrators of harassment. That's a different bill. But that is not the answer that people are leaving their jobs or are unwilling to take on these tasks because it's so hard, and it is hard, and I recognize that, is not the response. The appropriate response is not to not raise the rights of marginalized community members. That's all.
I got it. I mean, I
Yeah.
appreciate that. I think we're trying to balance here that workload and protecting kids.
Yeah.
But it's, yeah, I think what's the harm if we don't do this? And I think, I'm afraid the harm is significant. And so I too am learning as we go here. I know there's some personal stories that were just shared with us about situations that we'll get to the committee members. We're dealing with PCBs. I mean, do you put an extra, do you switch things around, or do you make sure kids aren't breathing PCBs? I mean, I'm like, okay,
Yeah.
don't breathe PCBs. I understand. I also have to, I worry a little bit, with all due respect to Senator Gulick. I don't want to keep calling this a crisis until we take more evidence and hear from, I think different schools are in different situations across the state. And I think we need to work with those that might be, certainly, we do need to work with those that are on the edge as much as we possibly can. But as it's been pointed out, depending sometimes where you live might impact whether or not your school is in crisis, the resources it has, et cetera. So you hear us all grappling and having this debate, but your testimony has been helpful to me, to understand the situation. And I have to wonder, or I do wonder, if you have it in writing, because it is
I'm happy to,
testimony
yeah.
that if you wouldn't mind.
I'm happy to provide that. I would also say that it isn't just where or which schools are in crisis, but the important question is who is in crisis. And ask that, if there's any hesitation, as you mentioned, bringing in the people who are most harmed by the existing policies and the existing trainings and the existing standard and laws are the people that you want to hear from. And as confident as I am in saying that I represent a lot of the voices that I hear, you need to hear from them directly, and that's important too.
Right. Related to Senator Gulick's question about, or her hope to bring some folks in, can you help us with that? This I don't know who Sparks is. Is that a?
I'm in contact with him.
Okay.
He's hoping he might be able to come in Friday.
Okay.
I would say that
And I recognize people are on vacation. It's hard. Schedules.
my work is such that I would not bring anybody in because it's all confidential.
Yeah.
But I do know that NAACP, there's a lot of community groups that do have those kinds of connections.
Yeah, we are
without
starting to
the
get some
confidential burdens that I carry. Rightfully so.
Yeah. Senator Gulick and then Senator Williams.
So just to be clear, you are putting the onus on the school, notice and failure to act after one event, after one transgression, correct? That's the new definition.
So that could rise to that a single act could rise to the level of harassment under the new definition, and that the onus is on teachers to report and investigators to review. But what we learn is that when they don't do that, they don't find it that there's more. Oftentimes, there is more, not just the one, but the one should trigger the report. And teachers, I think, would be glad to just report it to the administrator who's tasked to do that job, right? And the administrator who's tasked to do the investigation is supposed to be interviewing these individuals. The key is that knowing that it's just one time still requires you to review if there could be the possibility of there being more. That's it.
But you don't see the notice of failure to act after one event as adding to a more litigious environment in schools. You don't see that connection. You don't see that happening.
This isn't a strict standard that says anytime someone uses one word that you're going to court. It still says trivial inconveniences and petty slights are not actionable. And what we do know is that we have case law that says even one groping is not enough. We have case law that says sexual assault one time is not enough. And we're saying that's got to at least get in the door for an investigation.
We were told something different yesterday regarding from testimony that we had with, that wasn't necessarily the case with Title IX. Right?
This was Heather Lynn.
Yeah,
Would you remind me what you recall so I can just confirm?
that that one time did trigger action.
It should,
Yeah.
but it doesn't. And there's case law that has said one time is not, because the standard is severe or pervasive. And one time may not trigger severe nor pervasive. For sure, one time is not going to get you to pervasive. Rape will get you to severe, one time rape, but groping may not. Well, we don't know that. We do know that there's case law that says it doesn't, and we have some case law that says it could get in the door. But we've had cases across the country where they have said that has been lost. And the legal standard is still severe or pervasive to get into court. To hold a school accountable, you still have to show that it's severe or pervasive, regardless of what any policy says. We're talking about changing that legal standard so these kids get their day in court.
Thank you for your testimony.
Yeah.
Your calm demeanor, you know what you're talking about. You also said that you already know what the new Title IX is going to be. I asked the question the other day, if we already know what it is, why don't we start working towards it?
Yeah.
You know, if it's that important an issue, why I don't think we should wait. We should.
So they propose the regulations and then they ask for comments on it and then they finally adopt it. And usually you just wait for the final adoption. So before you act on it with policies and so forth.
So you've seen the
Proposed regulations, yes,
Okay.
yes. And what I'm saying is, having seen those proposed regulations, there's no contradiction there. You can create this law, this change now.
So what do they say about severity of offense?
Oh, that's still the standard.
In the
Yes.
new Title IX?
Yes, that's still the standard for it to be actionable, that it has to be severe or pervasive. Now, that's undisputed, that in order for a student to bring a case in court, it has to be severe or pervasive. Okay. Now, I want to tell you about a case that was lost at the Vermont Supreme Court involving a student who was raped, and she filed a claim, and the Supreme Court, the US Supreme, because the severe or pervasive standard, as I mentioned, is inconsistently applied across the country. And the Vermont Supreme Court even said at one point, the student lost on administrative reasons because they had not supposedly exhausted the process at their school. But before the court dismissed the action, the Vermont Supreme Court said, oh, well, we don't know that rape is bad, but is it even severe and pervasive? The Vermont Supreme Court even said, oh, the standard is severe and pervasive. There are courts across the country that are using an even more stringent standard that requires that schools, a case's action has to be severe and pervasive. We know that's wrong, that the legal standard is severe or pervasive. That's what came down by the US Supreme Court. But we're saying even the severe or pervasive standard is too high.
What year was that?
Which one?
What you did?
The US,
Vermont.
the Vermont Supreme Court? I don't know, last decade though. It's, yes,
Within the last decade.
yes, yeah. And the issue in that case, I remember it being that the student had reported the rape and the person who was receiving the report didn't know how to treat rape as sexual harassment. They said, oh, I didn't know, I knew it was like a sexual assault. I didn't know that was sexual harassment. Right, yeah.
One form that we got yesterday, summary of major provisions of the Department of Education's Title IX notice of proposed rulemaking.
Yeah.
Says that prohibiting all forms of sex discrimination. Proposed regulations would prohibit all forms of sex discrimination, including discrimination based on sex stereotypes, sex characteristics, pregnancy-related conditions, sexual orientation, and gender identity. And then it goes on in section 106.2, defining sex-based harassment, addressing off-campus conduct that creates or contributes to a hostile environment in a recipient's education program or activity, responding to sex discrimination, ensuring recipients learn possible sex discrimination. So it's got, I mean, there are 8 pages of,
It's almost like 100 pages of regulations
yeah,
that are coming up. Now, what's really, it's actually, these regulations are great. What they're doing is for the first time, we have a federal agency saying under Biden, that because a lot of these were lost under the Trump administration, that under the Biden administration, sex discrimination includes sexual orientation, rape, sexual assault, gender identity discrimination, and so forth too. And that's wonderful, but it maintains severe or pervasive for it to be actionable, because federal agencies don't change substantive law. They interpret existing substantive law. What you're being asked to do is change the substantive law in Vermont. You're being asked to change the definition and broaden the definition of harassment, which you can do. You can be protected. And there was a lot of testimony yesterday around how robust our bullying rules are. What is not before you today are the law around bullying. But I do want to just say they are not robust. We have kids who are, and families who are calling us every day about being bullied, and they have nowhere to go. We don't have jurisdiction over bullying. Nobody has jurisdiction over bullying except in schools. They are not robust, and we have families saying that nobody is addressing this. They don't have the right to appeal bullying to the agency of education. It ends where the schools end. And so relying on quote unquote robust bullying policies to address things that don't get in the, that are not severe or pervasive is insufficient. It is not enough, it's inadequate.
So for me, it's helpful just to think of the briefest description of what we'd be doing here. So I think of an elevator speech would be broadening harassment definitions with this, so that students get more of a voice, more of a hearing based on one situation. But again, for action to be taken, severe and pervasiveness would have to be proven in order for a student to be suspended or expelled based on. There's a protection around discipline for the student. It's more on the school itself. If they ignore it, then the school itself will be held accountable.
So
Tell me how much of that.
Yeah, also agree.
Okay.
Agree, so,
Okay.
right,
Yes,
yeah,
please.
so. If you change the legal standard and
Yeah.
broaden the definition by getting rid of severe pervasive, and you adopt what we say here, which is looking at the totality of circumstances, and that someone can belong in multiple protected classes, and that it's possible that one instance is enough, but if that instance cannot be a trivial slight or a petty inconvenience, or what did I say, petty inconvenience and trivial slight, I forget, is that if a school is on notice and a school fails to act, and a student can prove that that harassment is because of their membership in protected class, that they could bring a claim to court and that claim could get to a judge and that claim could get to a jury. Do we know that if they're going to be held liable? No, because it is ultimately up to the jury to determine whether that rises to just trivial petty inconveniences or whether it is harassment that as a society we go, we don't want this. We don't want this. Now, when we're talking about should we be disciplining kids who engage in harassment, that's a question for the disciplinary policies that each school adopts or each supervisory union adopts for how they ought to address that. I think there's some good statistics out there, which of course I don't have before me, is that very few students, especially around sexual harassment, very few students are being suspended or expelled for engaging in sexual harassment, like really low. So this idea that they're being suspended or expelled because of the harassment is not necessarily the case. But as I mentioned, if our concerns are around disciplining kids for engaging in harassment, that's not this bill. That could be a different bill that we could use.
Any other questions from Jen? Good testimony.
Thank you.
I mean,
Thank you
no
all.
matter whether we agree or disagree, I mean, it was well done for sure. Yeah.
Thank you so much.
And you'll
Thank you for all
provide
your
us
time.
with
I really
something in
appreciate it.
writing.
Absolutely. Yeah.
Ms. Garces, anything from you at this point? Or we're okay. Sorry.
Okay, thank you.
Thank you. We'll put this up for probably tomorrow afternoon to decide which way we want to move on this, Friday at the latest. If anybody needs to hear from anybody else, I think it will, actually, let's wait, we will hear from, is it Mr. Starks? Sparks, Mr.
Sparks. Just Sparks.
Just, that's his name.
Sparks.
Okay, good, so we'll hear from Sparks at some point, hopefully on this issue. Okay,